SJC-12173, Commonwealth v. Richard George.
If I may have a moment.
Thank you.
Mr. Hirsch, it's high noon, so you can say good morning or good afternoon. It's your discretion.
Good high noon, Your Honor, if it please the court, Mr. Chief Justice. With the court's permission, I'd like to begin with the second of the two issues, which is the adequacy, constitutional adequacy of antisocial personality disorder as grounds for commitment. I think we have a fascinating history of various courts relying on various other courts to really avoid dealing with this issue. We have Sousa and Husband, where the courts rely, where the appeals court relied on Reese. We have Mazzarino, where the court relied on Reese and Young versus Murphy. But if you look back, first of all, as I've written in the brief, all that it says in Reese is that, if the court excuse me for a moment, is that first, that the trial judge was wrong to find that the expert's pedophilia diagnosis was incredible, and then says the same diagnosis, in a footnote, the same diagnosis could be made with regard to the judge's assessment of Dr. Land's credibility regarding his expert opinion that Reese also suffered from an antisocial personality disorder. We need not discuss this, however, because either diagnosis is adequate to satisfy the definitional requirements of a sexually dangerous person. You could not find a better definition or a better example of dicta than that statement in a footnote on another, relating to another subject.
I mean, the statute does use personality disorder as one of the problems that would make for whatever the mental illness or.
But the statute is, the legislature in drafting the statute is not the constitutional arbiter. The fact that there are all sorts of disorders listed in the DSM. I recall one in one edition was math anxiety. The fact that it's there doesn't make it sufficient. Even the fact that it could lead somebody to be dangerous in a multitude of ways does not make it adequate. Humphrey versus Cady, the US Supreme Court said that there may be some way to distinguish sex offenders for justification for discriminating between sex offenders and all others for purposes of civil commitment. It may be sought in some special characteristic of sex offenders. Well, it can't be found in something that isn't particular to sex offenders, in something that a majority of prisoners of criminals have.
But the statute speaks of a personality disorder which makes the person likely to engage in sexual offenses.
Right.
So
And
I understand your point that merely saying antisocial personality disorder does not necessarily make the person likely to engage in sex offenses, but can't the experts say that this individual has an antisocial personality disorder that does make this person likely to engage in sexual offenses?
No, Your Honor, because the diagnosis must meet constitutional standards. And when we look at the various cases that have provided different reasons beyond ASPD for concluding that the ASPD itself was significant, was sufficient, you run into problems like what was said in the Cahoon case. The other evidence included age, incomplete treatment, lengthy criminal history, and the defendant's score on the static 99. But the problem is, none of those issues are diagnostic. So the issue still remains, yes, maybe we can come up with a finding based on these additional facts that this person is dangerous. But does the fact that the person has ASPD make that person likely to reoffend? They're two
Counselor?
separate.
How do you square your position with Dutille, which says that you don't have to, that the statute doesn't require express proof of a clinically defined mental illness and the Constitution doesn't require you to do so?
I have no problem with that in Dutille. In one of the cases, I think it was Husband, the court said, basically, I mean, the expert said, basically antisocial, but we're going to call it personality disorder, not otherwise specified. And the fact that it's not otherwise specified is not the problem with it. The fact that something may or may not be included in the book is not controlling here. It's the substance of the diagnosis. And if the diagnosis doesn't have the substance required to show this difference they talk about in...
So you say if a man or woman, anyway, there's a pattern of every time, multiple times of the expression of the antisocial personality disorder manifesting itself in raping somebody. He gets arrested, he's put in jail, he gets out, and he does it again. And the diagnosis is antisocial personality disorder. But that's all the surrounding evidence. And there's an expert who says, I look at all this, and based on my experience and training and whatever else, I can say to a reasonable degree of professional judgment that he is likely to reoffend sexually. And that's insufficient.
Correct, for one basic reason, Your Honor.
Yeah?
That confuses two elements. One is whether there is a personality or a disorder or a mental abnormality that meets constitutional requirements. The other is whether somebody is likely to reoffend. In the example you just provided, there's certainly evidence that the person is likely to reoffend. But I think what is missing here is consideration of what it means for somebody to act out in different ways on an antisocial personality disorder. I think we can look at, well, what is the impetus behind crime? I would suggest generally desire, power and anger, which can also be folded into desire. I want to get back at somebody, that's a desire. In that way of looking at things, there's no difference between somebody with ASPD who commits sex crimes, somebody with ASPD who steals, who attempts to kill, who robs. And that is not one of those special characteristics that distinguishes the sex offender from, as it was put in Crane and Hendricks, the typical, though dangerous, recidivist. And that's what has to be distinguished.
Is your position that the statute is only constitutional as applied to pedophilia?
Certainly not.
What other abnormalities?
I'm not even certain that it requires any kind of sexual disorder. I remember years ago representing a schizophrenic client. If the schizophrenia, and I really don't remember, had something to do with the fact that he kept on committing sex offenses, that might have been enough. But there are...
Okay, take that. Why isn't it enough if the antisocial personality disorder has something to do with why he keeps committing sex offenses?
Because the law requires that there be something to distinguish him from the typical, though dangerous...
Another ASPD person doesn't do that.
Well, you were asking about the psychotic, the schizophrenic client.
Yeah.
There is something that distinguishes him from the norm. He's psychotic, he's schizophrenic. The vast majority of people in the criminal justice system are not. But when you And that's
But
the
the
big
vast
problem.
majority, I would say, and I don't know this, but I think I can say, the vast majority of people with schizophrenia are not necessarily sex offenders, right? You have to look at the facts of the case.
I'm really not sure I'm getting Your Honor's point
Well,
there.
I guess my point is, somebody has a mental condition, and it manifests somebody will say, and the evidence, presumably there's enough evidence to support this, an expert will say that this mental condition manifests itself in a strong likelihood of continuously or just reoffending sexually. I just don't understand why that isn't enough.
Because of Crane and Hendricks, how is that person to be distinguished from the typical, though dangerous recidivist?
Well, isn't
the
that-
only thing is the nature of the crime, and that makes the nature of the crime itself a grounds for commitment.
Well, I'm a little confused, though. I don't know, but I assume the overwhelming majority of people with antisocial personality disorders are not sexual offenders. And if that's true, what you have is an expert saying that this person with this antisocial personality disorder, because of that, is likely to engage in a sexual offense. Why is that not constitutional?
Well, let's take it further. We can say the same thing about any other class of crime committed by somebody with antisocial personality disorder. We can say that the vast majority of people with ASPD who commit crime do not commit forgery, do not attempt to kill somebody, do not commit robbery. In each of these, we're saying that the antisocial personality disorder is not sufficient for commitment. This law says, well, it's sufficient solely because he acted out in this way rather than that, this criminal way rather than that criminal way. And that not only creates equal protection problems, but violates the mandate of the decisions by which this kind of law is made constitutional, Hendricks and Crane, because it doesn't distinguish him from, say, the typical rapist. The appeals court many years ago, in I believe it was the Jarvis case, said that rape doesn't necessarily show anything other than, doesn't necessarily express anything other than normal sexual desires, normal sexual ends. The fact that someone repeatedly acts on normal sexual ends doesn't distinguish him from the norm.
I guess I'm not sure I understand the premise of Jarvis. I'm not sure I agree with that premise. I guess that's my problem.
It's a 40-something-year-old appeals court case. I provided the site to...
Let me reframe the argument. I understand your argument to be, put aside the antisocial personality. Let's assume the person has a mental abnormality of very low IQ. If the QE were to say, yeah, he's got a mental abnormality of a lower IQ, and he is likely to commit sex offenses, and if the question is there any connection between his mental abnormality and his likelihood to commit sex offenses, if the answer is no, you win, because there has to be a mental abnormality that makes the person likely to engage in a sexual offense. It's not just mental abnormality plus likelihood. Correct?
Yes. My response, though, would be the fact that somebody has an abnormality makes him, that the fact that makes him likely to engage in crime, whatever the kind of crime, is not enough.
I take that point. But what if the QE were to say, in my example, this person has a very low IQ, which is a mental abnormality, and that low IQ, for whatever reason, makes that person likely to commit a sex offense? is that not okay?
It's a more difficult question because then we'd have to come up with some kind of analysis of what percentage of prisoners, what percentage of felons have a low IQ. Does that distinguish them from the norm? I don't know. And I would certainly argue against it, but it's more difficult.
But isn't that the stuff, though, not of sufficiency, but of cross-examination?
No, because the courts have been very clear that a particular kind of difference is required, that a difference is required. And here, all of the information before the court shows that ASPD does not distinguish Mr. George from anybody else in prison.
Okay, I have one more question, but not on this issue. It's been a while since I've seen the Static 99. Does Static 99 only say the category of low, high, medium, or does it say 11% over 5 years?
That is
20%?
changing. Up until the last couple of months, it said both. Now, Dr. Hansen and his colleagues have rejected high, medium, high, et cetera, for the very same reason I'm asking this court to reject it, that it has no definite meaning, and it can be interpreted any way by any expert.
So going for the Static 99, if you get a, whatever, a 7, it'll say 12 to 18% likelihood over 5 years?
7 would
Or
be
whatever.
considerably higher than that, but
Whatever, but I mean, but it will give an actual percentage likelihood over a
Yes.
period of time.
yes.
Okay, but that's new, that's not what happened in this, at the time of this trial.
Oh, it happened in this trial. Dr. Bell testified that with his score of 4, Mr. George had an 11% likelihood of reoffense. He then said, but I think that's too low for these factors, all of which was entirely appropriate.
Right, okay, thank you.
Thank you.
Good afternoon, Your Honors. Nathaniel Bodwin, Assistant District Attorney representing the Commonwealth. I just want to start out by saying the respondent's whole argument here about the clinical diagnosis of antisocial personality disorder is not really relevant because both of the qualified examiners testified that this respondent met the statutory definition of personality disorder. And as Justice Budd pointed out,
I'm sorry, the statutory definition?
the statutory definition of personality disorder, which is...
Oh, personality, okay.
Yeah, which includes in the definition a sexual element. The statutory definition says it's a mental condition that results in a lack of power to control sexual impulses. And the Dutille decision that this court decided said, the statutory definition may correlate with the clinical diagnosis, but it's not required by the Constitution. And whether or not the definition, can be found in a DSM-4 or 5 is really irrelevant here. Again, you had both examiners opine that he met the statutory definition. And I would also want to suggest to the court that this whole issue of the clinical diagnosis is not really properly before the court here today. There was no pretrial motion on this matter. The trial judge did not have an opportunity to even consider it. It was not the main crux of the defendant's argument at trial. It was discussed in terms of one article by Dr. Amy Phoenix, and the defense counsel in this case didn't even seek to introduce those articles as substantive evidence. She only sought to introduce them for impeachment purposes. So what you have here, is a due process challenge from the respondent based on a few sentences from one article that was produced the day before trial, and with that article, when the defense counsel cross-examined one of the experts, the examiner said she was familiar with that article, and she actually disagreed with the premise of the defense counsel, that actually what Dr. Phoenix says is, yes, perhaps antisocial personality disorder alone is insufficient, but what Dr. Phoenix actually said is there has to be a connection with an individual's sexual behavior. And that hurdle is met here with the Commonwealth's definition of a sexually dangerous person.
Was the witness testifying about the definition or the facts of this case? In terms of it has to connect to a sexual
I believe it had to do a little with both, And, you know, and in terms of the defense strategy that was put forward, really what the defense counsel discussed mainly was the fact that these qualified examiners were biased, that they were appointed and paid by DOC. There was a main focus on the disciplinary reports of this respondent while in prison, that they tapered off towards the end of his 25-year sentence. So again, this is not an issue that was brought properly before this court.
But do you agree with your brother that if the testimony had simply been he has an antisocial personality disorder, period, that would not be sufficient by itself to support a finding of a personality disorder?
Absolutely, Your Honor.
Okay, so it would have to be he has an antisocial personality disorder that makes him likely to commit sexual offenses.
That's correct, Your Honor. And I think if you look at the Mazzarino case, which was cited in the brief, that case said, you know, you have to have the condition combined with other evidence. And the statute really provides a whole range of ways that the examiners can look at whether a respondent is unable to control his impulses, and also whether or not he's likely to reoffend. And the Commonwealth went into great detail in the brief about what some of those factors were.
Can I ask you about,
sorry.
oh, go ahead, moving on to a different topic. Can you explain why it's fair for a QE to give their ultimate opinion about the likelihood of reoffense?
Sure. The case law, SDP case law, really says that qualified examiners are very unique forms of experts. They're actually integral to the entire civil commitment process. The qualified examiners have to be there at the temporary commitment hearing. They have to testify at the probable cause hearing, and their testimony is required at the trial because the question of whether a respondent is likely to sexually reoffend, that's a matter that's beyond the ordinary experience of a juror, and it requires expert testimony.
But I understand, so the expert should definitely, they testify by statute, but isn't it testifying about the ultimate issue that the jury is supposed to be finding itself?
I would suggest that it's not. I mean, because what the qualified examiners are opining about is whether they have a personality disorder or abnormality, whether that causes them to be unable to control their impulses, and whether it's likely for them to reoffend. So the jurors hear that, and they decide whether to credit or discredit that testimony, and then they come up with, and then they decide the ultimate issue, which is whether the respondent is sexually dangerous. And I think an important case with that would be the Johnstone case, which was cited in the brief, I believe the second one. And the facts of that are important because that was a situation where you had a respondent that was already civilly committed. He was petitioning for a discharge. The qualified examiners that were appointed by DOC in that case actually said, this respondent is not sexually dangerous. The Commonwealth proceeded to trial anyways, and instead of having one of the QEs testify, they had someone from the Community Access Board of the treatment center. And instead of having a QE testify, that person testified, and this court said that you can't do that. You can't have someone besides a qualified examiner say, this person can't control their sexual impulses, and they're unable to sexually reoffend. So following the logic of that case, SDP trials require qualified examiners to testify as to whether a respondent is likely to sexually reoffend.
And do you recall whether the testimony was framed in terms of a reasonable, to a reasonable degree of professional certainty, or what was the preface that was used for the opinion?
I don't recall at this moment how the question was phrased to the qualified examiners.
Would it matter?
Would it matter? I know that the law is changing in that area in terms of, whether, a reasonable degree of scientific certainty, but I can't answer that question at this time. I know that they were specifically asked whether he met the statutory definition. They went into a whole series of factors why he did.
Well, wouldn't they, I don't know this, and I could be completely wrong, but I understand they are unique experts, but they're experts. And it just seems to me that what goes along with being an expert witness is that you have to be able to say to a reasonable degree of whatever your expertise is in certainty, don't you?
Certainly, and what the Johnstone case actually says, it specifically says that these qualified examiners are different from other sources of expert testimony. So they really fall into a very unique category.
But partly that's because they get, more of them comes into evidence. I don't know that that necessarily means that their opinion doesn't have to be to a reasonable degree of professional certainty.
My assumption would be it was probably asked in that way, but again, I can't answer that at this
And is
time.
it a fair subject of cross-examination to inquire into what that means? If it's the term used by the expert?
Is it a fair question? Sure, it would be a fair question.
We turn to the Stag 99.
Sure.
Why is it fair, or perhaps why is it not unduly prejudicial to allow in the characterization of high, moderate, I assume low is not going to be a problem for the defendant, as opposed to the actual probability?
Because throughout SDP case law, it says that these static 99 scores are only one part of all the many factors that the qualified examiners consider. So it's not the basis. It's not like the examiners are going up there and saying, he has a 6, he's sexually dangerous, and that's it. They include that as part of a very broad range of factors that the qualified examiners consider.
But what, I guess the concern is, it seems that the low, moderate, high is meant to be among the class of sex offenders, this person is a higher risk, but that's different from saying it's a high risk.
Well, what the case law says is that the Commonwealth doesn't really have to come up with, doesn't have to say this person has a 50% chance. This person doesn't have to lay out a certain degree of what it is. It's just that they're, based on their condition, they're likely to reoffend based on their condition.
And what does it add beyond the percentage?
It's just one of those, it adds just as much weight as all the other evidence that qualified examiners testify to. The criminal sexual history, their behavior in prison, the facts of the sex offenses that they were convicted of. So it's just one of many, many factors.
About the words, low, medium.
Right.
Yeah,
I understand that it's perfectly reasonable to say that this person falls into the 12% likelihood of sexual recidivism over the course of 5 years. That tells you something. Moderate, high.
And I believe
I don't know what that means to a jury. I think what it means to Dr. Hansen is that among the class of sex offenders, he ranks higher than others. But isn't that more likely to confuse the jury in terms of what they're supposed to find?
Well, with regard to these changes with the static 99 test, and I do have some information on that, the labels are changing, and they've changed from low, moderate to high, and they've changed them to very low, average, and above average.
Isn't it like the DNA cases where we said, don't use the word match unless you give us some numbers, because a match could be a gazillion in some cases, or it could be in YSTRs 850. It's a big difference.
Yeah, and I would suggest that is different because in cases of fingerprint, DNA, that sort of thing, that is really a huge factor. That is almost maybe the main factor in those cases that juries consider, whereas a static 99 score is, again, just one of many, many factors. So it wouldn't have that same influence on the jury as with DNA evidence. And if there are no further questions, the Commonwealth rests on its brief. Thank you very much.
Thank you.